Good morning. I volunteer as the advocacy chair of the Albany chapter of the Huntington's Disease Society of America, and I serve as a volunteer on the New York State Department of Health's advisory committee for its Centers of Excellence for Neurodegenerative Disease program. My 37-year-old daughter is dying of Huntington's disease. I'm testifying to request that the Physician Aid in Dying bill be amended to include individuals with Huntington's disease and other neurodegenerative diseases. Otherwise, individuals with these diseases will not be given an end-of-life option. In so doing, the legislation will minimally achieve the vision set forth by New York Court of Appeals Justice Jenny Rivera when she said in her opinion in the Myers versus Schneiderman decision last September, quote, "Therefore, in my view, the state may not unduly burden a terminally ill patient's access to physician-prescribed medication that allows the patient in the last painful stage of life to achieve a peaceful death as the end draws near," end quote. The Huntington's disease community, through two major organizations, supports the individual's right to choose physician aid in dying. One way to achieve this is through the use of a prior healthcare directive and appointed healthcare agent. Those organizations are Help for HD International and the Huntington's Disease Society of America. A brief description of each is set forth in my appendix, together with Help's position paper and letters from HDSA to Assemblymember Paulin and the governor. We want to be included in A2383A. Everyone who cannot talk, cannot write, cannot swallow, are paralyzed, and whose capability cannot readily be determined are excluded. Permitting a prior healthcare directive and agent is one way to include everyone and is consistent with the reasonable accommodations requirements of the Americans with Disability Act. Why is Huntington's disease special? It's caused by a single genetic defect. You must inherit it from a parent. If a parent has it, the offspring has a 50% chance of inheriting it. It's always fatal, never goes into remission. If you have the mutated gene, you have the disease. There are no treatments or cures, and unlike cancer, there are no survivors. Many describe the symptoms of HD as having ALS, Parkinson's, and Alzheimer's simultaneously. It takes many years to die. As your muscles stop working and rigidity sets in, you can have painful muscle spasms. HD is one of 10 diseases eligible for medical marijuana in the original New York State legislation. It is on Social Security's compassionate allowances list of diseases. In the late stages, the person with HD can no longer walk and will be unable to speak or swallow. However, he or she generally is still able to comprehend language and retains an awareness of family and friends. HD has many times the national average of suicide. There's a predictive genetic test for it. People have time to think about their choices. I filed an amicus brief in the Myers appeal. I discussed the situation of a dying person with Huntington's disease, or ALS, who has decided not to have a feeding tube inserted and slowly starves themselves to death. New York allows a person to decide to end medical treatment even when that results in death, and that decision is permitted to be made in advance via a healthcare directive and appointed healthcare agent, or when necessary, a surrogate. And it survives subsequent incompetency. And we all know, as was stated so eloquently in another amicus brief submitted on behalf of a group of New York State legislatures, the stated difference between an act of omission and an affirmative act is false. To quote that brief, quote, "This false distinction is founded in the fiction that removing life-extending treatment at a patient's request is somehow passive. Sedating someone into unconsciousness while withdrawing food and water is not passive. Quote, pulling the plug is not passive," end quote. These are affirmative acts that are no doubt difficult, and as the brief said, they are now an intrinsic part of medical care. Revealing this fiction completely undermines any distinction between using a prior healthcare directive for terminating medical care and using a prior directive for physician aid in dying. Unfortunately, I have known too many people with HD and ALS who chose to starve themselves to death. This is not an easy thing for the family to watch. I mentioned two, Laura with HD. She was in a nursing home in Vermont, a state that allows physician aid in dying. Laura was determined incompetent because she was unable to drive, pay her bills, or manage financial concerns, and, in my opinion, the convenience of the doctors. But she could make medical decisions. When she returned the food trays with the uneaten food, she knew the difference between life and death and the type of life she wanted to live. No one helped her. On August 1st, 2015, the Times Union newspaper published Laura's story. I mention a letter that Karen Pass sent to Governor Cuomo in March of 2016. It's included in full in my exhibits. She writes of her ALS husband's helplessness and plea, "Do something, kill me, let me kill myself. Why won't they let me kill myself?" Many ALS patients avail themselves of palliative sedation, taken off the ventilator, placed into a coma, and not given food or water. We do not know for sure if people in a coma feel pain or have a sense of their surroundings. There must be a better way. Then there's Barbara, who took her HD husband to Switzerland to die with physician assistance. He had to go while he could still travel and speak, so it was before he would have preferred. But no state in the United States would give him the mercy he desired. Why Switzerland? The definition of terminal illness does not include a within 6 months of death provision. The clause in the Oregon law requiring the dying person to be within 6 months of death is arbitrary. In Oregon in 1994, they looked for an easy definition of terminal illness and adopted the hospice Medicare definition. However, in 82, when Congress added hospice to Medicare, the 6-month provision was put into the definition as a fiscal cost containment measure. Congress wanted to limit the amount of federal funds spent on the program. 6 months has no moral, ethical, or medical basis. New York must not make the same mistake that other states have made by copying the Oregon law. The Oregon law simply does not work for anyone dying of a neurodegenerative disease like Huntington's. Physician administered is needed because, as the record in Myers demonstrated, there are complications. People throw up the barbiturates, regain consciousness, and die from the underlying illness. The complications may be underreported because this is something people do in the privacy of their home. Canada and Belgium permit others to administer. This is not in my written testimony, but please note that physician-assisted and prior healthcare directives would solve many of the problems that witness Dr. White spoke of. We are not alone in the quest for inclusion of people with neurodegenerative diseases. The Economist came out in favor in June 2015. Nurses in Quebec, Canada, caregivers of people with Alzheimer's in Canada and in Oregon. And in Oregon, there's a movement, as reported in the March 11, 2018 edition of the Washington Post, which also reported on the objections of Compassion and Choices, reported as being that people should be able to speak for themselves. Today, people speak for themselves through a prior directive. In New York, we even allow a healthcare agent for someone who never had the capacity to make a healthcare decision, the mentally retarded. Take a look at New York Surrogate Court Act Procedure, Section 1750B. The legislative record for this law provides that people with mental retardation deserve, quote, healthcare rights essential to the human and dignified treatment to which every other citizen is entitled, end quote. See the bill memo that accompanied Assembly 8466D, which became Chapter 500 of the laws of 2002. The pending legislation must be consistent that everyone deserves health care rights essential to humane and dignified treatment. No argument against a prior directive is valid against the standard we have afforded the mentally retarded. Compassion and Choices is simply wrong and behind the times on this point. While the timing should be a private matter between the patient and their doctor, at the very least, when a person has a terminal illness, needs a feeding tube or a ventilator, they must have the right of physician aid in dying. There can be no doubt that at this time, when the patient's rights to privacy and self-determination are paramount to any right or interest of the state government in overruling the patient's choice. What Justice Rivera was talking about. A choice other than starvation must be made available. So why did the people I knew with Huntington's disease refuse feeding tubes when they could have extended their life? Because their life was unbearable. My daughter watched her mother slowly die and spend years rigid, unable to move any body part, unable to speak, orally eat, with painful muscle contractions. No hope for a miracle drug cure being researched. My daughter has a healthcare prior directive not to prolong her dying. She was a woman of the world, a Peace Corps volunteer who served her country by teaching English to the children of Turkmenistan, who worked and lived in Thailand teaching English to children. She volunteered as an English teacher to foster care children in Israel. She lived for 18 months in Argentina. She speaks 5 languages. She toured the world. She has made her choices. She wants the same right of choice that's being considered for other people dying of things like cancer. Let's not leave anyone behind. Thank you.
Thank you. Couple of things. Number one, could you email us your brief in the Myers case?
Certainly.
Secondly, I gather, correct me if I'm wrong, you have 2 concerns. Number one, people who expressed a desire for aid in dying while they had capacity, but then lose capacity?
Yes, so it would be the same as terminating medical care. We have a huge and lengthy history of what has happened when people refuse medical care, and there's no abuse.
And the second point is to allow other than self-administration if the patient is physically incapable of self-administering?
Yes, that's correct. I had a conversation recently with the chairman of the Oregon Assembly Health Department, Mitch Goodlick, and he was telling me that many ALS patients have come up with ingenious ways to self-administer, including driving their wheelchairs into walls to activate a plunger that inserts it. There has to be a better way. Canada, Belgium allow it to be physician-administered. If it was physician-administered, it would solve all the problems that the previous witness, Dr. White, talked about. Not all, but a great many.
Yeah. Now, under a healthcare proxy or the Family Healthcare Decisions Act, decisions have to be guided by the reasonably known wishes of the patient, or if those wishes cannot be reasonably known, then the best interests of the patient. Would you argue that aid in dying should be available to the agent or surrogate on the same basis as other withdrawal of life-sustaining treatment?
As a secondary to the patient expressing their own preferences in a prior directive.
Okay. Is that spelled out in more detail in your brief? Do you think?
I don't think so, but I do have a brief, amended suggested language. It certainly could be a starting point for discussion.
Okay. If you could also send that to us, that would be helpful.
I have a copy with me today if you'd like me to hand it in.
Easier if you can email it. Just
Absolutely.
makes it easier to handle. Thank you.
Absolutely.
I appreciate that. Other questions? Yeah.
Thank you, Mr. Chairman. I know I'm not on the committee. I just want to, Mr. Pfeffer is a constituent and an extraordinary advocate, so I just want to welcome him.
Let me just introduce you to the room. Assemblymember Fahey, and at the end of the table, Assemblymember Byrne.
Again, I'm no questions. Just want to welcome a constituent who has been an extraordinary advocate, and thank you for your questions. I'm happy to help with any follow-up. So thank you, Mr. Pfeffer, for your incredible advocacy and knowledge.
Thank you, Assemblywoman Fahey. If I may just have 10 seconds, let me indicate that the definition that's in the amended version of the bill is stricter than last year's version in the definition of what constitutes a terminal illness. So the witness who spoke about losing, people being forced to make a choice because their insurance company would not pay for treatment is actually addressed by the current definition of terminal illness, which is stricter and narrower, which provides that if a treatment is available, a person is not terminally ill. Thank you.
Thank you.